Hello and welcome to the second lecture for topic 3. In this lecture, you're going to learn how the Supreme Court incorporates the Bill of Rights to the states. We're going to also revisit the 14th Amendment and explain why the 14th Amendment is important to incorporation. And then we're going to examine the key cases and Supreme Court tests that are used for incorporation. So let's go ahead and get started. Okay, so in the last lecture, we learned that coming out of the Barron versus Baltimore case, that when it comes to the question about whether or not the Bill of Rights applies to the states, at that time of Barron versus Baltimore, that it was concluded that the Bill of Rights restricts only the powers of the federal government. It does not restrict the powers of the state government. In other words, the Bill of Rights only applies to the states. Now, thinking about the purpose of the Bill of Rights as exclusively limiting the actions of the federal government reflects key assumptions from the founding. Early on in the semester, I was telling you that the Bill of Rights is sort of seen as a thou shalt not. It's telling government what it cannot do. It restrains, it restricts, it places limits on the government. And, coming out of Barron, that where they say, we have the Bill of Rights, but it really only restricts the actions of the federal government, that is a reflection of some of the assumptions of the founding. And the main assumption is, and for those of you who have taken American government or taken an American history class, there was this real concern about national government when the United States became its own nation and created its first constitution. There was all these concerns that the national government was dangerous, right? That was the government that we should really be worried about. That it's the national government that, if they're unrestrained, they can do a lot of harm to the people and the states. State governments, the assumption is that they were viewed as less harmful to the people. And that's not because, the founders felt that, that government was, some type of government was good and some type of government was bad. It's just that the national government was sort of abstracted from the people, right? Because it was like people from the different states going to government, and that they maybe weren't as closely connected to the people in the states, and therefore it's easier to abuse your power. Whereas with state governments, it's sort of like there's a closer connection between the government and the people, because they actually live in that state. And so, from that perspective, it was like, hey, we don't really need to worry as much about state government. And we can restrain the state government at the state level. But really, it is this assumption that most of the damaging impacts of government is going to come from the national government, from the federal government. The assumptions that the national government is the government that should be feared the most, right? That has the greatest power of treading upon our liberties. That really changes quite significantly following the Civil War. And so following the Civil War, it states, and in particular the former Confederate states, that were seen as capable of doing harm to the people that live in the states, especially harm to African Americans who were former slaves within the Confederate states. And so, coming out of the Civil War, and keep in mind, if you've taken any history classes, coming out of the Civil War, that, you have these radical Republicans. Abraham Lincoln was a Republican. I mean, I don't think he would be considered a radical Republican, but there were a lot of Republicans that were really sort of, wanting to make it very, very difficult for the Confederate states to join back in the Union. And they were very suspicious, and probably with a lot of justification, that if the Confederate states didn't have tons of breaks and restraints placed on them, that they really would be harmful to the people in their states, particularly to those who used to be slaves. And so the purpose of the 14th Amendment, and I know we mentioned this in the last lecture, but it's just important. It's such an important amendment, and it's going to have huge implications, obviously, for the incorporation of the Bill of Rights, that the purpose of the 14th Amendment is to place restraints on the power of states following the Civil War. And the 14th Amendment is basically saying that, states can't take away any benefits or protections that come with being a citizen of the United States. And in a second, we're going to relook at the language of the 14th Amendment. But one of the provisions of the 14th Amendment is if you were born here, you're a citizen. And that, the framers of the 14th Amendment were like, you know what? That might not be enough. We've got to tell states that, these newly freed people are citizens and that they have certain fundamental rights as being citizens. And states can't take away the benefits and the protections that come with being a citizen of the United States. They also said, hey, states, you can't take away a person's life, liberty, or property without following due process. In other words, that the state governments must abide by established laws and legal procedures if they want to take away somebody's life or property or freedom. Okay, they are bound by law. And so the 14th Amendment and these two provisions are, just really key to sort of understanding what the intent of the 14th Amendment is. That is this distrust of former Confederate states and being very, very plain about what they cannot do. And it really sets the stage for understanding how these provisions of the 14th Amendment are used to basically apply the Bill of Rights to the states. And so let's relook at the language of the 14th, and then let's move on and take a look at the cases that help us understand the incorporation of the Bill of Rights. And just for good measure, let's read the Section 1 of the 14th Amendment of the United States Constitution. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. A very important Section 1 of 14th Amendment, very important. In the yellow is the Privileges or Immunities Clause, and in the orange is what's known as the Due Process Clause. Now, as we know from the last lecture, that once the 14th Amendment is added to the United States Constitution, people turn to it as a means of supporting the claim that the Bill of Rights applies to the states, right? So it's like Barron happens. It's like, hey, the Bill of Rights doesn't apply to the states. The Civil War happens. So the 14th Amendment is added to the Constitution, and it renews people's efforts to say, wait a second. Based on what the 14th Amendment is saying, that all those privileges and immunities, all those liberties, where do we find those? We find those in the Bill of Rights. And therefore, basically, it's saying that states can't take away those rights either. So, people turn to those, to the 14th in order to incorporate the Bill of Rights. Now, the first effort at incorporating the Bill of Rights following the Civil War, it uses the first of those two clauses, the Privileges or Immunities clause. And that comes forth from the Slaughterhouse Cases from 1873. And as we know, that spoiler alert, that the decision in the Slaughterhouse Cases basically guts the Privileges or Immunities clause. It essentially writes it out of the Constitution, and it hasn't been used since. Couple times. We can talk about that in office hours if you want to come, since 1873. So knowing that that is a dead end for the incorporation, when it's clear that the Privileges or Immunities Clause will not be used for incorporation, people turn to the Due Process Clause. And it's the Due Process Clause that's used to incorporate the Bill of Rights. Okay. So a lot of preliminary work there, some of that, a refresher from last lecture, but that's okay. So let's turn our sights now to the cases, and starting with the landmark case called the Slaughterhouse Cases. Okay, so as I mentioned on the last slide, the Slaughterhouse Cases from 1873 is considered a landmark case for the Supreme Court. Now, you'll notice that, it's not just case, and it's not like Barron v. Baltimore. But as you read in your textbook, that the Slaughterhouse Cases is a collection of cases that are brought to the Supreme Court, all dealing with the same issue or the same topic, which we'll talk about in a second. So sometimes when that happens, they just, instead of referring to each case separately, they'll just say, hey, it's the Slaughterhouse Cases, dealing with this slaughterhouse in the city of New Orleans. And I asked you what you thought like landmark cases of the Supreme Court were. You'd probably say like Plessy v. Ferguson, Brown versus the Board of Education, Roe v. Wade, maybe District of Columbia v. Heller. I'm sure there are some landmark cases that you could come up with. But I doubt that you would say the Slaughterhouse Cases, because it's usually sort of underplayed as not being like this hugely essential case. But it is, and hopefully I'll make a case for why it is in fact a landmark case. So one of the reasons why it's a landmark case is it's the first time the court is given the opportunity to interpret the 14th Amendment. So check out that date, 1873. And the 14th Amendment was added in 1868. So anytime this very important amendment, but anytime a provision of an amendment comes, or a provision of the Constitution, the body of the Constitution comes to the Supreme Court for interpretation, it's really important, because how the Supreme Court interprets that provision of the 14th Amendment can have huge implications for future understandings of that amendment. And that really is the case with the Privileges or Immunities Clause in the Slaughterhouse Cases. It really defined how we think about that part of the 14th Amendment moving forward. This is also just a weird case. I mean, weird in like a cool and good way, but it's weird because it's a product of a very specific time in American history. So for one, this case comes from the state of Louisiana, in particular, the Crescent City, New Orleans. And so, Louisiana is an interesting state, in regards to the United States because of its demographic makeup, right? It has these French roots, right? That is very unique and different. French and Spanish roots that is very different and unique from the other, early states in the United States. This is also, an interesting case because the law that is in dispute in this case is the product of the radical reconstruction that began to take place, but was not supported for very long, that took place in the South. And so the law that's in dispute is the product of the first biracial legislature in the state of Louisiana, because it's a product of radical reconstruction, basically telling these former Confederate states that you have to let African Americans vote. And when African Americans vote, they elect, not always, but sometimes, African Americans. And so for the first time in Louisiana's history, not only is it just like right after the Civil War, but you have a demographic makeup of the state legislature that is reflective of the actual demographics of the state of Louisiana, which includes African Americans, obviously. Another cool, interesting aspect of this case is that the butchers are represented by John Campbell. And John Campbell was a former member of the Supreme Court prior to the Civil War. He left the Supreme Court to join the Confederacy, and he actually was like one of the right-hand men of Jefferson Davis during the Confederacy. So again, pretty bonkers. And that the butchers who are bringing suit against the state of Louisiana for the passage of this monopoly slaughterhouse, which we'll talk about in a moment. The butchers are from French heritage, and they are really proud about their butchering tradition, and they feel like this monopoly that's been created is taking away their right to be butchers, to practice their livelihood in this trade that's hugely important to them. But what's sort of ironic about it is that they turn to the Privileges or Immunities Clause, that provision in the 14th Amendment that was really designed to protect the rights of African Americans. But hey, if the clause is there, use it to protect your own rights. And that was the effort that they pursued. And then finally, that the opinion for the majority that's written in the Slaughterhouse Cases by Supreme Court Justice Miller, he absolutely hates John Campbell, this former Supreme Court justice who left the Supreme Court to join the Confederacy. So here he is, he's a Republican, and Justice Miller is supportive of Reconstruction in the South. And here he is, having to listen to an argument in favor of the Privileges or Immunities Clause incorporating the Bill of Rights. This isn't why he gutted the Privileges and Immunities Clause, not because of his dislike of John Campbell. But he ends up, basically making the Privileges or Immunities Clause completely meaningless from this point forward. And we'll see why that is in a moment. And so, this is a very strange case for many reasons, but it's landmark in terms of it gives us an understanding of the 14th Amendment's Privileges or Immunities Clause that basically makes it have no power. And it really sort of changes the trajectory in terms of the way we think about the incorporation of the Bill of Rights. So let's dig in and take a look at the actual facts of this case. Okay, so what's going on with the Slaughterhouse Cases? Well, the Slaughterhouse Cases, to get a full understanding of this case, you have to know what life was like in New Orleans at this time period. And so, as many of you know, New Orleans is on the Mississippi River. It's at the very end, the southern end of the Mississippi River. And for many, 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 many years, livestock producers would put their cattle and their hogs onto barges, and they would, ship that livestock down to New Orleans. And then New Orleans, there were, hundreds of slaughterhouses that were independently owned and operated, where they would the livestock would come to the New Orleans. They would get off the ships at a landing, and then different butcher shops would come, and they would get those animals, and then they would take them to their individual butcher shops and butcher them. And that it really created a really gross environment in New Orleans. New Orleans was known as a necropolis, not like a metropolis, but a necropolis, because you could die there because of the unsanitary conditions, particularly in the summer, from the slaughterhouses. Because, they'd slaughter the animals, and then any parts that weren't used, like the entrails or the tongues or whatever, they would just put it in the Mississippi River, and, that would float down to the Gulf, but it would also get in the New Orleans water supply, which was completely disgusting. I have a hard time sort of thinking about it. And so, this is a case about that the state of New Orleans, in order to address these unsanitary conditions, not the state of New Orleans, but the state of Louisiana, in order to address these unsanitary conditions, they passed a law that created this monopoly slaughterhouse, and it's called the Crescent City Livestock Landing and Slaughterhouse. And they basically said that this is the only corporation, it was a monopoly, that can actually slaughter animals. Nobody else can slaughter animals anymore, okay? And on the top there, that picture on the top, that's a picture of the Crescent City Livestock Landing and Slaughterhouse. It was a huge operation, but it was a monopoly, and the thinking is that if you just had one corporation that was dealing with it, they could reduce sort of the waste that got into the rivers. Well, this case is about a bunch of butchers. Those butchers, right? The Crescent City Livestock and Landing company, they got a 25-year monopoly in order to do the butchering, to do the slaughtering. And all of those independently owned and operated butchering slaughterhouses, they were, shit out of luck, right? They could no longer engage in their livelihood. And they were pissed off about that. And so that they created this society called the Butchers Benevolent Association, and that's a picture of the butchers below. And they basically said that even though they could rent, like a stand within that large operation in order to do butchering, they felt that their livelihood was grossly curtailed and that their rights were being taken away. And so the Butchers Benevolent Association sues the Crescent City Livestock Landing and Slaughterhouses, basically saying that in the state of Louisiana, creating that monopoly deprived those butchers of their rights. Okay. And so let me take the magic pencil off here. And so those butchers said they looked at the 14th Amendment privileges or immunities clause for remedy. They actually also looked at other provisions of the 14th Amendment. They looked at the due process clause. They said that their due process, their liberty had been taken away without due process. They also said that they were being discriminated against. So they actually looked at the equal protection clause. And they actually even argued that they had been put into involuntary servitude because they had to get a stall from the corporation, right? Basically making them slaves, right? And so they basically threw all of the 14th Amendment at the court, saying that they had been harmed and they were seeking remedy. And they were smart because they had lost at the state court level. And so then they argued it from a federal perspective. That is the 14th Amendment that allowed them to get a hearing at the Supreme Court. So that's the issue before the court. And the court rules against the butchers. And so let's take a look at the reasoning of the court. So what was the question before the court in the Slaughterhouse cases? Well, the question before the court was, well, there were several, but we're just going to take a look at the one as it's pertinent to our discussions about the incorporation of the Bill of Rights. The question was, were the butchers' rights deprived of rights to conduct business under the Privileges or Immunity Clause? And the court, in a close ruling, they ruled no in a 5-4 decision, that the butchers' rights were not violated. And the reasoning is, well, they said that the law didn't violate the Privileges or Immunities Clause. And what they said was, they said that the clause, the Privileges or Immunities Clause, only forbids the states from withholding the privileges and immunities belonging to American citizenship, not state citizenship. And so they basically said that the Privileges and Immunities Clause is about the Constitution granting these broad national rights to citizenship, not all these specific rights that are granted to you at the state level. And so they basically said, hey, the Constitution, for example, in Article 4 says that a state can't discriminate against out-of-state residents, okay? So like if you're from Wisconsin and you go to Illinois, you can't be discriminated against. And they said that that's the extent, that's how they interpreted the Privileges or Immunities Clause, really, really narrowly. They basically said the Constitution does not require a state to grant like special privileges, like a right to start a slaughterhouse to every one of its citizens. And if you read in the excerpts from the decision in the textbook, it's basically like you could tell the court was really worried. I mean, when you look at the Privileges or Immunities Clause, it sort of seems obvious that all the liberties in the Bill of Rights would be incorporated to the states, because if all, the freedom of speech and the freedom to, protest and the right to be, have privacy in your home, if those aren't privileges and immunities, then, what are? But you can tell that the court really did not want to say, yes, all of those liberties apply to the states, because they really felt like that would give the federal government way too much power. It's basically telling the states that they have to afford all these liberties to people. And the court really did not want to go there. And so they basically said, oh, the Privileges and Immunities Clause is really, really narrow, and it cannot be used to assume that all the liberties in the Bill of Rights applies to the states. As it says at the start, the P or I clause, path to incorporation, is a dead end, same as the cows, sad face, because all the cows and hogs died. Because with this decision, the court effectively gutted the Privileges or Immunities Clause. They basically wrote it out of the Constitution, and it's been rarely used, if ever used, since. Okay, so it was clear that the Privileges or Immunities Clause was not going to be the means for incorporation. So maybe it would be the Due Process Clause. That would be a more successful means for incorporating the Bill of Rights. So the question is, hey, will the court use the Due Process Clause to incorporate the liberties that are in the Bill of Rights to the states? And if they do that, like, which liberties? Are they going to basically say, hey, yeah, states can't deprive you of liberties without the due process of law, and that means all the liberties in the Bill of Rights? Or are they going to just go select a few? Say, well, maybe not all the liberties apply to the states, but some few fundamental ones. So let's look at the cases that give us a sense of how the Supreme Court is going to incorporate the Bill of Rights to the states. Okay, so the following three cases give us some insight into how the court is going to use the due process clause for incorporation. And so let's take a look. I'll just put these up here and we'll talk about each of these individually. So the first case that your textbook talks about is Hurtado v. California. And this is a case about whether or not the states can deprive an individual of the right to a grand jury. That's a provision in the Fifth Amendment. This is a case about Joseph Hurtado and his wife Susie. They live in Sacramento, California, and that a friend of theirs, Jose Estuardo, comes to visit. He starts getting friendly with Joseph's wife, and that really makes Joseph angry. And at the end of the day, he gets so pissed off at Estuardo hitting on his wife that he ends up killing him in a bar. Joseph Hurtado is charged with first-degree homicide, and that he is ultimately found guilty and sentenced to death. Now, upon appeal for his conviction, his lawyers argued that Hurtado's rights have been violated, and therefore the decision, his guilty conviction, should be overturned. And they said that his rights were violated because when he was charged with the crime and bound over for trial, that he was charged with the crime not using a grand jury, but using this thing called an information. And so the state of California allows people to be charged with the crime and then sent to trial through this thing called an information. But Hurtado's lawyer said, no, you have a constitutional right from the Fifth Amendment for a grand jury if you're going to be charged with the crime. The Supreme Court did not agree with Hurtado's lawyer, and they upheld his conviction. They basically said that the grand jury, the right to a grand jury, is not a fundamental liberty. And so it's not a liberty that is going to be incorporated to the states. However, they left the door open and said that other liberties could potentially be incorporated to the state. They basically said that the due process clause can't be used to incorporate all of the liberties in the Bill of Rights, but some of the liberties, particularly those liberties that are fundamental to living in a democratic society. And for their perspective, the grand jury, we could still live in a just society and a democracy without the right to a grand jury. And so they said, nope, not going to incorporate the right to grand jury, but we're still going to leave the door open for others. Chicago, Burlington, and Quincy Railroad versus Chicago, 1897. This is a case that's somewhat similar to the case in Barrett versus Baltimore. This is a case having to do with eminent domain and whether or not a state or city can take away your private property without compensating you for that. And so Chicago was developing its city, and it took private property away from private citizens, but also from a privately owned railroad. And the railroad cried foul. They only got $1 for their property. Here's my dog. Say hi. And they said that their rights to just compensation from the Fifth Amendment was violated, and that the due process clause applies that to the states. And the Supreme Court agreed. They said compensation for property is a fundamental liberty, and they said that states could not violate that fundamental liberty in the Fifth Amendment. And so that is the first liberty that's incorporated to the states. And then Maxwell v. Down is about a case about a bank robber, Maxwell Gunplay Maxwell, and that basically robbed a bank, and then he was charged without a grand jury, and he was tried under the Utah law that says that you don't need to have 12 jurors, you can only have 8 if it's a non-capital offense. His lawyer he was found guilty. His lawyer cried foul, and so the Supreme Court said, well, trial by jury has never been affirmed to be a necessary requisite for the due process of law, and so they didn't incorporate that to the states. So right now it's sort of like maybe the Supreme Court is going to incorporate these liberties, maybe not, but right now they're sort of all over the map. Grand jury and right to jury trial isn't fundamental, but the right to just compensation is. So it looks like we need to have a test or a standard so that we have an idea of actually how these liberties are going to be incorporated to the states. So the test that develops that's going to be used to incorporate the Bill of Rights to the states emerges from a series of 3 cases: Twinings versus New Jersey, Gitlow versus New York, and Palco versus Connecticut. You can read about these cases in more detail in your textbook. I'll just summarize what the main sort of takeaways from those cases are in terms of the incorporation of the Bill of Rights. Twining is important because it provides an outline for the test or the standard that's going to be used by the courts to incorporate the Bill of Rights to the states. It says that in that ruling, they say that some liberties are fundamental and will be incorporated to the states, but it's going to happen on a case-by-case basis, which we sort of got a sense from that in the Hurtado decision. And so basically that answers the question about whether or not the Bill of Rights will be incorporated all at once. Total incorporation, that would be all of the liberties 1 through 10 would be incorporated to the states, or was going to take place selectively, selective incorporation, case by case. And so in Twinings, we learned that it's going to be selective incorporation, that every liberty, a case is going to have to come to the Supreme Court, and they're going to ask the question, should that be incorporated to the states? Do the states need to recognize that fundamental liberty? And the Supreme Court will answer yes or no. Gitlow versus New York is an important case because it recognizes more fundamental liberties. It incorporates the freedom of speech and the freedom of press to the states, and basically says that these liberties are fundamental and states cannot violate those liberties of freedom of speech or press. And then Palco v. Connecticut, which we'll take a look in a little bit more detail on the next slide. The court defines what we mean by fundamental rights and the process that's going to be used, that needs to be used as rights are incorporated. So let's look at Palco v. Connecticut. All right, so let's take a look at the case Palco v. Connecticut, which establishes the so-called Palco standard, and it's the standard that the Supreme Court uses to incorporate most of the Bill of Rights to the states starting in the late 1930s. So Palco v. Connecticut is the story of Frank Palco, and it begins in Connecticut, where he robs a store, and in process of robbing the store, he shoots and kills 2 police officers. He's arrested, and when he's questioned by the police, he confesses to the killings. And so then he is charged with first-degree intentional homicide. During his trial, the judge at his trial said that the confession could not be admitted into the court. It could not be used. The jury couldn't consider it. And so the jury was unable to convict him of first-degree intentional homicide because they weren't able to use the confession. And so Frank Palco was found guilty of second-degree homicide, and he received a mandatory sentence of life imprisonment. The prosecutors cried foul in Connecticut, and they basically said that the judge was in error when the judge would not let the confession be used in court. And so they appealed to the Connecticut Supreme Court of errors, and the Connecticut Supreme Court agreed with the state prosecutors, that they said that, yep, the judge should have allowed that confession. And so they allowed for a new trial of Frank Palco. And Frank Palco was tried again, and that he was found guilty of first-degree homicide, and he was sentenced to death. So the question in Palco versus Connecticut revolves around the question of double jeopardy, and that, whether or not you can basically be charged twice for the same charged and tried twice for the same crime. And that seemed to be the case in the Palco case, right? That he was tried twice for the same crime, and that the second time he got the death sentence. And so the facts of the case are interesting and sad, because as we're going to see, that the Supreme Court did not think that the double jeopardy clause of the Fifth Amendment should be incorporated to the states. But why Palco is important for our purposes is because it gives us the test for what should be considered in terms of what rights must be applied to the states. And so it asks us the question, what are fundamental rights that must apply to the states? And in the Palco decision, they say that that principles of liberty and justice, which lie at the base of all of our civil and political institutions, if the liberties deal with those sort of those fundamental principles of liberty and justice, they must be applied to the states. That if the very essence of a scheme of ordered liberty, rooted in the traditions of conscious in the traditions and conscience of our people, if the liberties rise to that magnitude, they must be applied to the state. And that if we didn't apply these to the states, neither liberty nor justice would exist. If they weren't applied to the states, then they must be applied to the states. And so the Palco standard is really basically saying that there are these liberties that are necessary in order to have a democracy, that are necessary for liberty and justice to prevail. And if we sacrifice to these certain liberties, then basically that we're sacrificing the very fundamental foundations of living in a just and democratic society. And so they're basically sort of opening the doorway to say that if you can demonstrate that these liberties are fundamental and necessary to the very essence of a scheme of ordered liberty, then they must be incorporated to the states. Unfortunately for Frank Palco, double jeopardy is not one of these rights. However, it is today, because nearly all the rights in the Bill of Rights have been incorporated to the states. So in many ways, we have the Palco standard, which basically gets people and lawyers thinking about how to prove that these liberties are in fact fundamental. And if you can deem them fundamental, then they will be incorporated to the states. Okay, I want to draw your attention to table 3.2 in your textbook that basically shows you the specific cases as it relates to the specific amendments as they're incorporated to the states. But I also wanted to show you this chart as well. It comes from my American government text, and I kind of prefer this chart because it basically shows you sort of the long history and just how long it took to incorporate the Bill of Rights to the states. So it starts with eminent domain, that provision about just compensation for private property that's taken. We talked about that case. It starts in 1897, and it takes all the way until 2010 in order to incorporate the Second Amendment, the right to bear arms. And a lot of the incorporation takes place, particularly for the rights of the criminally accused, during the Earl Warren Court when he is the Chief Justice. And so it's really, only been, 50 years or so, a little bit more than 50 years, where those who are accused of crime really have a robust protections at the state and local level as it relates to their rights. All right, that's it for me this week. Thanks for paying attention. I know this material can be a little bit dry of corporation, but hopefully the lecture brought this topic to life for you. So finally, next week, looking forward to next week, we finally get to start civil liberty case law. Not that we haven't dealt with civil liberty cases, but doing it in a more systematic way. And so we're moving away from foundations and that we're beginning with the First Amendment. And the first provision in the First Amendment has to do with religious freedoms. So next week, we're going to start the free exercise of religion. So woo, we finally get specific in terms of the First Amendment and our civil liberties as it relates to that. Thanks a lot for paying attention, and I'll talk to you again soon.